You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements.
Tens of thousands of people hear these words every day, but very few of them know what they really mean, and this can have some scary consequences.
The legal system can be like going to a foreign country where you don't know the language or understand the customs. If you don't have someone to advocate for you, to help you, it can mean the difference between your freedom or incarceration. And in some places, it can mean the difference between your life or death.
Unfortunately, not everyone in this position has the means to hire someone to help. Today, 80% of people who are arrested need a court-appointed lawyer to help them navigate the criminal justice system. But this option wasn't always available. That is until 1963, when Clarence Earl Gideon, a man who was too poor to afford an attorney, forever changed the process in criminal court cases. On June 3, 1961, a robbery occurred at the Bay Harbor Pool Room in Panama City, Florida. Beer, soda, and $5 in change were taken, and multiple items were damaged. Later that day, a man was arrested for breaking and entering and theft because a witness claimed to have seen him near the pool hall with pockets full of change and carrying a bottle of wine. That man's name was Clarence Earl Gideon. Clarence Gideon, a 50-year-old electrician with an 8th grade education, arrived at the courthouse alone. Too poor to afford a lawyer, Gideon requested that the judge appoint him counsel, but this application was denied and the following conversation took place.
Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I'm sorry, but I will have to deny your request to appoint counsel to defend you in this case. The United States Supreme Court says I am entitled to be represented by counsel.
Subsequently, Gideon was forced to represent himself during the trial. He did a fair job in court. Nonetheless, based on one witness's statement alone, he was found guilty by the jury and sentenced to the maximum time of 5 years in the Florida State Prison. From his cramped prison cell, Gideon filed a writ of habeas corpus petition for the Florida Supreme Court. This is a petition for release for unlawful imprisonment. He stated that he had not been given a fair trial because his constitutional rights under the 6th and 14th Amendments were being abused when the court would not appoint him a lawyer. Gideon's petition was dismissed. Soon after, Gideon, writing from prison, filed an appeal to the U.S. Supreme Court in a suit against H.G. Cochran, the Secretary of the Florida Department of Corrections. This appeal was not reviewed until 2 years later, in 1963, after Cochran had retired and had been succeeded by Louis L. Wainwright. When the U.S. Supreme Court finally did take up the case, they appointed future Supreme Court Justice Abe Fortas to defend Clarence Gideon, while Bruce Jacob fought for Florida.
Number 155. Clarence Earl Gideon, petitioner, versus H.G. Cochran, Director, Division of Corrections.
On March 18, 1963, Supreme Court Justice Hugo Black delivered the unanimous decision that Gideon's conviction was unconstitutional because any individual charged with a crime punishable by time in jail or prison had the right to an attorney. The Sixth Amendment, the right to counsel, is a fundamental right applied to the states through the 14th Amendment to the United States Constitution's Due Process Clause. It requires that indigent criminal defendants be provided counsel at trial. The case of Gideon v. Wainwright concluded that a defense attorney is fundamental and essential to fair trials in the United States, overruling the previous case, Betts v. Brady. Based on the Supreme Court's decision, Clarence Earl Gideon was given a new trial. W. Fred Turner was appointed to Gideon in his second trial. The verdict came back as not guilty, and Gideon was given his freedom. Subsequently, thousands of other initially convicted people were also retried with counsel and acquitted of all charges. Because one innocent man who was too poor to afford an attorney stood up for what he believed was just, the right to counsel for all indigent defendants in criminal cases was born. Now, 50 years after that landmark case, we are still trying to fulfill Gideon's promise. Back in 1963, when this important decision was made, not only were Clarence Earl Gideon and thousands of others who were unjustly imprisoned freed, but the public defense system was formed. The public defense system in the United States is a cornerstone of our democracy. It is meant to ensure that everyone accused of a crime gets a lawyer, even if they can't afford one. However, while this is the goal of the public defense system, in reality, it is not being met everywhere. Continuous underfunding and overwhelming caseloads for public defenders are putting this country at great risk for not fulfilling one of its most important promises, to provide quality representation to those in Wisconsin. We are fortunate to have a strong statewide public defender system. In fact, in this past year, Wisconsin's Public Defender Agency celebrated its 35th birthday while the nation was celebrating the 50th anniversary of Gideon versus Wainwright.
Being a public defender is very rewarding work because you are helping people who are in need. They're in a stressful time of their lives when they have criminal charges that they're facing. It's hard work because for the same reason that there's a lot of stress and pressure that the lawyers take on trying to help people in need. However, it's very satisfying because you are making a difference by helping out people who really need that help.
Wisconsin's Public Defender Agency has close to 40 offices across the state, with approximately 300 attorneys and just as many support staff. The agency also appoints private attorneys who are certified to take public defender cases in overflow and conflict situations.
In many states, public defenders have caseloads which are 2-3 times what public defenders in Wisconsin carry. No attorney, even the most brilliant attorney, can handle that kind of a caseload and provide effective assistance of counsel.
In Wisconsin, attorneys are appointed for any cases where an individual may face jail time. If a person qualifies for representation by a public defender, the Public Defender's Office is required to defend them. Therefore, the Public Defender's Agency has no control over the number of cases they represent across the state. In the past couple of years, that number has averaged approximately 140,000 cases per year. While these sorts of figures result in extraordinarily high caseloads for Wisconsin's public defenders, Gideon's promise is indeed being met in Wisconsin, thanks to the passion and commitment of the people that have dedicated their lives to helping others that can't help themselves.
That come across us, that meet us, that interact with us, one thing they can really see and feel is our passion for this work, day in and day out. And people that work for the Public Defender's Office tends to believe this in their soul.
Many may wonder why any of this matters to those who aren't accused or don't know people accused of crimes. Or why does it still affect us 50 years later?
It should matter. It's extraordinarily important, and it's one of those rights that I think so many of us have gotten used to, that we are not diligent in making certain it's being provided to everyone. We've grown complacent. Having a right to counsel is what stops us from being not only just charged, but convicted, incarcerated for something we may or may not have done. It's leveling the playing field in the justice system, which is so important. You have all the government resources on one side, and you have you as an individual. And oftentimes those individuals are at their most vulnerable and critical times in their lives, and to not have someone who has that expertise and that educational and that ability to fight for your rights. All of us lose something in our society, not just that one person, but we all do, because it's so important. What's more basic in our Constitution than our liberty? And when we give that up, when we start to chip away at that, we give up something so fundamentally important, and that should be important to all of us.
None of us know for sure what the future may hold. If you or one of your loved ones winds up in trouble with the law, I believe that we would all want someone there defending us against all odds. So each and every day, as a defendant stands beside his or her court-appointed attorney, Gideon's legacy lives on.